Good morning, everyone. Let's start the class for today. Right, we're doing civil procedure today, and last week we finished off the first block. All right, just to give you an idea where about we are in the block right now. Let me share it with you. All right, remember here, this one. We started off with 7 blocks, I said to you, isn't it? That 7 blocks tell you how you start a case from the beginning up until the end. So the whole 28 chapters, which you have 28 sets of notes, it's about how you start a civil case from the beginning, identifying all the parties up until you finish appeal. So I look at it under 7 blocks, and I keep repeating these 7 blocks again and again because I want you to look at it this way. Students that don't do well in civil procedure, they always have that perception it is bulky because they have 30 plus chapters, and I keep saying to you, you don't look at it particular way. You look at it that you only have 7 blocks, and out of that 7 blocks, we dive and separate into it. So the first block, it's about getting everything ready so that we are ready to go into the courtroom. Everything is on standby, we can start the case. So, limitations. Limitation is a defense. Alex sued Mr. Lee. Mr. Lee checked whether he can raise defense of limitation. Alex also check and see if limitation is an issue which will bar him from suing. And then we have jurisdiction of courts. Which court should we sue? Is it session court? Is it magistrate court? Is it high courts? Now after that, it's about mode of commencing. Do we start with a writ or do we start with originating summons? How about parties? Is it Mr. Lee? Is it Lee Senjaran Berhad? Is it Lee Partnership? Is it trade union society? Which parties? And under parties, we also have different things as in non-joinder, misjoinder, intervener, a lot of things which I asked you to make table, things like that. Parties, we also look at it with service. Once you know which party is it, how are you going to serve that document, the writ or statement of claim? Is it to the company? Is it to this particular address? Is it to the director? Okay. After looking at a service, and we also have a substituted service, we also have service of jurisdiction, then we look at what if we don't comply with the rules, order 1A, order 2. Appearance. Appearance is for the defendant. It's for the defendant to enter appearance. It's as if the defendant telling the court that I want to defend myself. And if the defendant didn't enter appearance, the plaintiff may then enter a judgment in default of appearance, JIDA, against the defendant. So we got block 1 settled. Now we are into block 2. Okay, we are into block 2. So what is block 2? Shaping the dispute. How the case is structured and who is is it involved. Now, maybe you say who is involved is in party, yes, okay. But what about, we always say, apply, by notice of applications with supporting affidavits. So what is the affidavit? We actually read through Order 41 together, isn't it? When we read the statute. So this thing, we can actually go through it quite quickly. So we will use 1 session this morning to do it. And then after that, we use 2 sessions to go through pleading and amendments of pleadings. I was thinking, should I put in third party, but I think it's a little bit too much. I can, but then it's like trying to squeeze everything in there. So we will do this one and this one today. Pleadings and amendments of pleading. Pleading, as it say, okay, don't confuse. Pleading means statement of claim, statement of defense, okay, all these things. Writ is writ, OS is OS. They are not pleadings. Pleadings are statement of claim, statement of defense. So when we look at pleading, we have what is the pleading? What is the rule on pleading? How do we write pleading? What are the things we can write in there? What are the things we cannot write? What about amendment of pleadings? How do we amend pleadings? What are things that we can amend? We also briefly look at the statute in this particular part, like your Order 18 and Order 20. Now I know when I keep mentioning about this order, you may not be you may not familiarize with it because it's still, quite new to you. Because I'm sure that you keep doing it, all right? You keep looking at it, and it will come naturally to you. Affidavit Order 41, Pleading Order 18, Amendment of Pleadings Order 20. So you don't have to particularly go and purposely memorize it. It will come naturally to you. Okay? So today we are doing Chapter 8 and Chapter 9. Proceedings in Chambers and Affidavits, and also Pleadings and Amendments of Pleading. All right? Next class, and then we'll do third party combined with a little bit of Block 3. Okay. Now let's look at here, Proceedings in Chambers. Not a lot of case, and I'll tell you which one is it that is really that you need to know. So again, summary questions, you know what to do, and also case summary. Now, there are 3 cases here. The first 2 cases of Lee Tai and Tan Sri Ngan Chin Wen and Arab Malaysian Finance and Sirajuddin, they are both against and under. As in, not really say that, but they kind of... Lee Tai is the case where they said that... What is it? It's the issue of this one. Affidavit affirmed before filing of originating summon. So, if you have an affidavit that affirmed before filing of originating summon, is the affidavit valid or not valid? One case say valid, another case say no. Now, then, is it conflicting with each other? Not really, because if you really read the case and we read the case together, it seems the judge kind of differentiate the facts. And I also given you this yellow color case, which is less important, Sangjit Kaur Dior, which is para 9 to 21. It's a case where you can use to illustrate and help your articulation when it comes to question involving affidavit. When there is a question involving affidavit, the particular pattern that they set the question in exam is always the same. Always the same. They will give you 3 scenarios, and the total marks will be about 9 marks. One, they say this affidavit contains hearsay, blah, blah, blah. Second, this affidavit is affirmed, blah, blah, blah. Third, this affidavit is written in Chinese language, blah, blah. So you have to go in and analyze each one of that particular statement and see if that particular affidavit is valid or not valid. Okay? So, let's look at proceeding in chambers. Now, proceeding in chambers is basically in chambers. In chambers means in the judge office. For those that you have been to the court, you will note that when you went into the court, when you sit at the back of the court, and we talk more about this when we do criminal, okay? When we talk more about this when we do criminal, then when it's time, 9 o'clock, and the clerk will say, court, and then you all stand up, isn't it? You stand up, you bow. And the court will walk out from a door beside the stage, not stage, his place sitting, and walk and sit. Behind that door, that will be his office in chambers. So there are certain things we say in chambers, there are certain things we say in open court. When we say in open court means it is open. Anyone can come in and sit and listen to it. You can go to a high court now or even session court magistrate and just open the door and walk in. You can, because all court cases are open court case. But there are certain particular applications, issue to be dealt in chambers. When it's dealt in chambers, basically it is only the judge in there and also your lawyer and the defense lawyer. Let's say you are the plaintiff, and that's 3 parties there. So it's not open court. So what are some of the things where it is proceedings in chambers? Means it's not open court. Then, for example, interlocutory application. For example, injunction. Okay, for example, this kind of third party. Okay, where you apply ex parte, all these things. Is made after commencement. Its purpose to obtain an order for specific matters before trial or before hearing. You can obtain once it's hearing, then the other part. Let's say ex parte means you go one-sided. You go alone. Once there is a date for hearing, a hearing of a third party proceeding, hearing of a injunction, then the other party will come. The other party will be the defendant. Example, interim injunction, amendment, discovery, summary, striking out. So your particular order, it's order 32 and you use form 57, which is notice of application, support by affidavit, heard in chambers before a judge. That's it. Okay, it's just a background knowledge for you. Now, what about affidavits? We have actually read affidavit together, but let's go through the second time now. So we have read it together for the first time when we read the statute, isn't it? So let's read it again second time. So open up your statute, and I'll share the statute together with you as well. And let's see, this is order 41. Let's make sure, where are we? Give me a minute and let me get that. Okay. Okay. So very straightforward. When it's question on order 41, all you have to do is just to answer based on your statutes. Okay, let's share. Wait a minute, you cannot see, right? Okay. Right, let's start. Form of affidavit. Subject of paragraph 2 or 3. Every affidavit sworn. Affidavit is a sworn statement. In a cause of matter, shall be entitled in the cause of matter. Okay? Where a cause of matter is entitled more than one matter, it is sufficient to state the first matter followed by the words and other matters. So affidavit is that sworn statement. Now I want you to look at this one. Order Rule 1 sub 4. Every affidavit shall be expressed in the first person and shall state the place of residence of the deponent, and if he is or is employed by a party to cause matter which the affidavit sworn, the affidavit shall state the fact. So your affidavit must have this particular thing. Okay? Take note, must have this thing. Provided that in the case of deponent who is giving evidence in professional, business or occupational capacity, the affidavit may, instead of stating the deponent's place of residence, state the address of which he works, the position he holds, and the name of the firm employer, if any. Every affidavit shall be divided into paragraphs numbered consecutively, each paragraph being, as far as possible, confined to a distinct portion. So that is your particular affidavits. It has to be in a particular format. Every affidavit shall be signed by the deponent, and the jurat shall be completed and signed. The jurat shall be in the form 74. So you can look at your rules of courts. How does form 74 looks like? Okay, so give you an idea in case you don't know what's a jurat. It's like a sworn statement lah. All right, let me give, not sworn statement. Surat akuan. Okay, should I say it? It's like you do it in front of the Pesuruhjaya Sumpah. Okay, surat, jurat. Okay, it's like you have sworn, affirmed this particular thing, to take an oath that this is something true, real. Okay, it's a statement of endorsement. Okay, statement of endorsement. Okay, statement. It's to show that this thing it's true, it's not fake, it's real. Okay, all these things. Jurat. Okay, I'll tell you where you can see this. I'll show it to you. Yeah, Chief Registrar, you can see here, frequently asked question, this surat, jurat. statement of endorsement, translation, edits, serve an evidence being read, explained into interpreter, the blind or whatever, illiterate, commissioner of how that the blind. So you can see this is a statement of endorsement. Okay, statement of endorsement. Okay, here. Affidavit by illiterate or blind person. Where it appears to the person administering the oath that the deponent is illiterate or blind, he shall certify this. Okay? And take note of this one, use of defective affidavits. An affidavit may, with the leave of court, be filed or used in evidence, notwithstanding any irregularity in the form thereof. Right? The court may allow it to be filed even if it's not that particular accurate bets, but then it's up to the discretion of the court. What about the contents? Okay, then you see contents, only see contents here. This is with regard, deal with the issue. And sometimes when you see in question, exam talking about the affidavit hearsay statement, can affidavit have hearsay statement or not? Then you look at Order 41, Rule 5. It says that subject to Order 14, Rule 2 and 4 sub 2. Why to subject Order 14? And then you look at Order 14, which we haven't do yet, which we'll do soon. Order 14 is what? What is Order 14? Order 14 is summary judgment. Order 14 summary judgment. Under Order 14, Rule 2 sub 2. And it says that, I read to you Order 14, Rule 2 sub 2. Unless the court otherwise direct, an affidavit for the purpose of this rule, what rule? Order 14, Rule 2, may contain statements of information or belief with the sources or grounds thereof. Meaning, when you apply for a summary judgment, under Order 14, Rule 2, your affidavit may contain hearsay evidence. You may not understand what is hearsay right now, but take it as it is. When we do evidence, you understand. So it says here, come back to here, Order 41, Rule 5. Subject to Order 14, Rule 2, sub 2, 4, sub 2 to paragraph 2 of this rule to any other. And affidavits may contain only such fact as the deponent is able to, of his own knowledge, to prove. Meaning, under Order 41, Rule 5, a general affidavits, you can only have information that you know yourself. You cannot have anything that is hearsay. That is what it says here. You read on. Affidavits sworn for the purpose of being used in interlocutory proceeding may contain statement, information, and belief with the source and ground hereof. It means that if you are applying for some kind of interlocutory thingy, interim payment, striking off injunction, in your affidavit, you may have hearsay statement, but you must state the sources. You may have, but you must state the sources. However, if you are applying for something that is not interlocutory, you are applying for something as a final judgment. So for example, you are applying, let's say, something for a final judgment. Now you are using notice of application plus affidavit. That affidavit cannot have hearsay evidence in there. Okay? Get around it. Understand from the statute. The statute says if it's used for interlocutory, you can have hearsay, but you must state the source. So you must state the source. So it means that if you are applying for something for a final judgment, then your affidavit cannot have hearsay evidence in there. What about scandalous? The court may order to be struck out any affidavit, any matter which is scandalous, irrelevant, or otherwise oppressive. In your affidavits, if you start to say you're a liar lah, you're biased lah, you're racist lah, it's nothing there. It's just alleging something. So the court may strike out that thing. So it's up to the court. The court may strike out the whole affidavit, or the court may just strike out the particular 1 and 2 paragraph which contains this scandalous thingy and take in consideration paragraph 4, 5, 6. It's up to the judge what he wants to do. So alteration, okay, you can read this on your own. If you wanted to amend affidavits, so normally you use a red pen to cancel and then bracket underneath what are the things you want to amend. So basically this is what they tell you. Affidavits not to be sworn before solicitor or party. An affidavit is not sufficient if sworn before the solicitor of the party on whose behalf the affidavit is to be used or before any member of the firm of that solicitor. Okay, so you have to sworn, they want it to be independent. So you have to sworn it outside, find someone, okay? Because you cannot ask your own lawyer to sworn it on behalf of you, affidavit. You will find some other third party to sworn. So that's why sometimes you see, let's say in a law firm, you're handling a case, you need an affidavit to be sworn, you go opposite another law firm, hey, can you sworn this statement from me? So you go someone outside. You cannot also find someone inside your law firm to do it for you. Okay, that's what it says. Document annexed to affidavits. Any document to be used in conjunction shall be exhibited. Exhibited means attached to it like that. And copy thereof annexed to the affidavits. Okay? Exhibited, should I say attached? Means show, I'll say show, exhibit. Because when in criminal, we say barang case is exhibit. Any exhibit to an affidavit shall be identified by a certificate of the person before whom the affidavit is sworn. The certificate shall be entitled in the same manner as the affidavit. This rule shall apply. Okay, take notes. Affidavit taken outside Malaysia admissible without proof of seal. A document purporting to have affixed or impressed thereon or subscribed thereto to the seal and signature of a court, judge, notary public, or person having authority to administer oath in Commonwealth country. Okay, Commonwealth. And in the case of any other country, the seal signature of consular office, Commonwealth country in the testimony being taken before, without proof, judge, notary public, or person. Basically, if you take something affidavit outside Malaysia, it's admissible if you comply with this particular rule. It was taken in front of a judge, blah, 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 all these things. Okay? And lastly, language. An affidavit of deponent affirmed outside the jurisdiction, outside Malaysia, may be filed in English, and unless the court otherwise order, need not be accompanied by a translation in national language. Right, so I give you a case here. The case that I give you is Sanjit Cordio. It's not as in a landmark case, but it's the case where you can use to articulate and explain further to support your explanation. Okay? Where is it? Here. All right. So what particular paragraph I want you to read? 9 to 21. All right. There's no need to summarize because whatever you summarize is in on your statutes, Order 41. Okay, look at 9. See that legal principles. Order 41. This is about hearsay. Then you say here. As a general rule, an deponent to an affidavit need not state the source of information or belief. This only applies to interlocutory proceedings. In a proceeding where the parties are seeking final relief, a deponent to an affidavit must state only the fact which the deponent is able to prove. Failure to state the source or information when the deponent avers he was advised will render the averment into the category of hearsay evidence. So, if you are applying for interlocutory, you can have hearsay, but you must state the source. But you are applying for final, you cannot have hearsay. It must be something that you know only. Okay, you can use this, whatever it says here, Sanjit Cordio. In dealing with Order 41, Rule 6, based on the way, what is scandalous? Okay, then you see that? You can use this definition of scandalous to help you articulate. So I give you this case. What is irrelevant? Okay, scandalous. Order 41, Rule 5 until paragraph 21. All right. Okay, until here. So it's just nothing too much. Basically, it's the same in affidavits. It's the particular question that you get when it comes to affidavit is always standard one. So I use this case to help you articulate and also whatever we read there. Okay, now come back here. You see, in affidavits, so far, I don't think there is a need for you to make any notes, all right? Because I think if you look at last few weeks, every chapter like parties and service, I kind of draw it out for you, what kind of notes you can draw, so you have a visualization of the charts. Here, it's just a very small chapter. So I don't see there is a need for you. If you want, then it's up to you. Okay, if you want, but I don't see there is a need to do anything in there. All right, so in affidavit here, we look at this one already. But there is also another thing that you need to know, which is this one. Affidavit affirmed before filing of originating summons. What does it mean? When you start a case, you use writ or OS. If it's writs, then you attach your pleadings, statement of claim, or this thing. If it's OS, what do you attach? OS, you attach with affidavits. Okay, OS attached with affidavits. So you can look at OS order 7th. Okay, OS order 7th. Okay, OS, you attach it with affidavit. Writ, statement of claim. So the issue here was OS is like the cover letter. Writ or OS is like the cover letter. Is to mode of commencing, isn't it? Is to start a case. So you must have a writ first, then only then you can start. You must have an OS first, only you can start. So now the issue is, you have an affidavit first, only then you go and file the OS. It's like saying the cover letter goes later. It's like the content come out first, cover letter later only you go and file. It's like, cannot write, because the flow is not shouldn't be like that. The flow should be like, you have OS, you initiate the cover letter, only then you attach the affidavits. So just write, just ngam. But then it's like now, you have affidavit first, then after that you only file the cover letter OS. So the particular urutan, okay, the flow is not right. So the issue now is, if you have an affidavit, affirm before filing of OS, meaning you have affidavit here, later on only file the OS. Is this affidavit valid or not valid? So there are two cases here. There are quite some cases, but I give you two cases. And you will need to know the fact of the case, so that if there is a question in there, at least you can differentiate and explain what happened in this particular case, what happened in this particular case. Let's look at Lee Tai and Tan Sri. I think let's look at this one first. Arab Malaysian Finance. Okay, let's look at Arab Malaysian Finance. Which one comes first? Let me see. 1998. Okay, let's do the 1998 one. Okay, Arab Malaysian Finance first. So I want you to read the case. Okay, please, whole case, and you must know the facts, so that at least in the question, if there is a question, they do have question here. You can explain, and you can compare, contrast with the questions of the fact. The facts of the question, to see, can we differentiate to say this is valid or this is not valid. So now you have an affidavit affirmed before filing of OS. Is the affidavit valid or not valid? Let's look at Arab Malaysian Finance case, Sirajuddin bin Muhammad Ismail whole case. And I'll give you here the summary. Plaintiff, so I go through the summary for you. Granted a loan of 500,000 to this company, secured by a third party charge over the defendant's land. Borrowers defaulted. So plaintiff filed an OS dated here to foreclose. Foreclose means take the property and sell off to recover the money. Affidavit in support were affirmed a week earlier. So he has the affidavit first, later on only he go and file the OS. Defendants argued the affidavit was inadmissible since it was affirmed before even the OS existed. So the argument was, affidavit attached to OS. If you have affidavits and you don't have OS, so the affidavit attached to nothing. So the affidavit is invalid. You don't have that cover letter. Plaintiff relied on this case which accepted affidavit affirmed before filing. Whether an affidavit affirmed before OS was filed could constitute a valid Order 41. So this is again the old rules of High Court 1980. After that, now you have rules of Court 2012. Affidavit must be in the cause of matter. If affirmed before a case, it cannot be properly entitled, is invalid. A cause of matter is only exists when a case is registered and given a number. Affirming affidavit before means it's not sworn. Affidavit in interlocutory or ex parte may be accepted if counsel undertakes to re-swear them, but not where the affidavit forms the core evidence. Such an affidavit is still a stillborn, meaning you don't have things to attach to. Whereas a cover letter, you cannot revive it. It's a nullity. You can use the word nullity. Okay? All these things are old act, require the affidavit to be served 4 days before hearing, but do not permit it to precede the existence. Affidavit affirmed a week before OS was filed was held invalid and nullity. So you don't have to go into this so much key principle because here is an old kind of concept, but I want you to know the facts and what's the reasoning. The decision say, without a valid supporting affidavit, the OS was unsupported and has to be dismissed with cause. So now you dismiss with court dismiss, so the court will grant ang pao money to the person, okay, the opposite party because you didn't follow particular procedure. An affidavit must be affirmed in a cause of matter that already exists in the registry. Affirming it before filing creates an affidavit for a non-existent case. So this is your reasoning. You should have OS, then only affidavit. If attached together, then it's valid. So now you have affidavit with nothing to attach to, then the affidavit is invalid. Unlike interlocutory application, this affidavit is the foundation of the OS. Its defect was substantive, not procedural. Order 2, Rule 1 cannot cure. Following, okay? So I want you to know the facts. If you can read the case, I want you to know what happened in the facts. It was affirmed a week before. Okay? Now, let's move on to the next case. Next case is Li Tai. Li Tai, I want you to read 323 to 327. So Li Tai case came after Arab Malaysia Finance. So he compared Arab Malaysia Finance as well. So here, plaintiff and others members were permanent members for Selangor Chinese Assembly Hall. They sought declarations of perpetual membership and mandatory injunction to restrain amendment to the rules. Plaintiff OS was filed on this date, but his supporting affidavit was affirmed 3 days earlier. So again, issue. He has an affidavit, later on only filed the OS. Defendant objected that the affidavit supports were inadmissible because there's nothing to attach to, relying on the Arab Malaysian Finance. Again, same issue. Key principle, again, Order 41. Affidavit sworn, kewangan bersatu, all these things. So, almost the same key principle. However, the court now said differently. The court dismissed defendant first preliminary objection. What is preliminary objection? Preliminary objection is the objection where you object against the other party for certain kind of procedure that he didn't follow. Okay, in case you didn't know. Okay, legal tactic where party formally raise an issue often about jurisdiction, admissibility that must be resolved before the main case can be heard. So, you are normally not allowed to raise preliminary objection like during the trial. Because this thing, if you realize that the other party did it wrongly, didn't do it properly, you should raise it immediately with him and give him time to remedy it. You cannot keep it to your chest. Okay, keep it to your chest means keep your cards to your chest and later on during trial and stand up and say, Judge, please strike out because he didn't. You are not allowed to do that. And you also see, you have your Malaysian Bar. Remember Bar Council ruling? Okay, notice of preliminary objection. So you must give advance notice. You cannot like last minute. So, court dismissed defendant preliminary objection. Holding affidavit affirmed 3 days was curable. Curable irregularity. So sometimes student will say, okay, affirm 3 days is valid. So if another student, your curable irregularity, you see the difference? Okay, learn to use this professional term. Arab Malaysian Finance say nullity. Here say curable. Why? How come so different? Plaintiff later affidavit reaffirm the content and rectify. So first thing that is difference between here and Arab Malaysian, this is where you differentiate. In Lee Tai, he filed the OS on this, he filed affidavit on this day. He filed OS on this day, 3 days later. After that, he realized he made a mistake. He quickly filed another affidavit later on 7 June, okay, to reaffirm and rectify the technical defect. So at least he did something. Court distinguished Arab Malaysian Finance. In Arab Malaysian Finance, affidavit was a week early. That's why I want you to know the facts. In Arab Malaysian Finance, affidavit was affirmed a week earlier. Here, delay was only 3 days and due to public holiday, technical reason. Courts adopt liberal approach and then that's why. So I don't want you to, I often also seen sometimes students learn in this particular way. Or a week cannot, 3 days can. So now, 2 days can or not? 5 days? I keep saying to all of you, in law, there's nothing as 1 + 1 = 2. So we have to look at a lot of different kind of factors. You see, this case of Lita, he looked at, he did really file an affidavit later on to remedy it. It was 3 days, not so much compared to Arab Malaysian Finance. It was public holiday, technical reason, okay, liberal approach order 2 rule 1. So they look at quite a lot of different factors to decide. So I want you to have these two cases. So in case there is a question, you can analyze both cases, compare and contrast, and also argue, particular in that question, who are you advising? How do you want to analyze? So don't twist the fact of the question to suit your needs. Argue based on the fact. Okay? So these are the cases I want you to know. Right? Then we're done with this one. Alright? We're done with this one. So let's look at the next one. Pleadings. Alright, pleading is a big chapter. Okay, what time is it now? Okay, let me start a little bit of pleadings just to give you a heads up, then we go for a break, okay? Because if I try to fit third-party procedure, maybe it's a bit too much. So let's keep a bit slow, okay? I hope you are fine with it. Now in pleadings, pleadings is about statement of claim, statement of defense, all these things. So these are all the things you need to know before you can go into the exam hall. So these are the questions I keep saying to all of you will be very useful to you when it comes to revision, okay? Cross-check yourself. Do you know this? Do you know that? Now there are some cases in here. Okay, if you look at all these cases in there here for you, I also give you the cases in here, correct? But if you look at all these cases here, I didn't give you any summary at all. No summary compared to other. Why? Because I was thinking that if I leave it like this for you to read, I think you will end up hating me. Okay, I think you will end up, your answer may go haywire. So I thought that it's much better I do it for you. I tell you which one is it that I want you to extract. Okay, so you see I give you the facts, help, same thing. Here. Facts, help. I extract the particular thing I want that I think you should know. So that's why I didn't give you a summary in each case. There's only one case I give you summary here, which is this one. Instant color and ink maker. Okay, very often tested, so you need to know. Now you also see one of the cases here there is no quote because I didn't put a quote here because this case I don't know where should I put it. This case cover functions, rules of pleading. It also cover issue as in like can you raise an issue in trial is not pleaded. So I leave it there to you here. That's why I haven't got a quote here. So green color only read when you're free. Okay, para 15 to para 19. So in here I separate into two parts. Chapter 9.1 is pleading and chapter 9.2 is amendment of pleading. So as the word suggests, amend. So in pleading, actually there are quite some other things, but these are some of the important things that you need to know. So 1.2, 1.1, 1.2, 1.3, 1.4, 1.5, 1.6, and 1.7. All right. Now, functions of pleadings, this one, functions of pleading, you don't have to memorize. It's just very general. Once a while, you tend to see them ask you in a question. You just answer whatever you know on top of your head. 4 marks, 5 marks. Rules of pleading, this one is from your statute. Order 18, Rule 7 to Rule 12. So we will read the statute together again for the second time because we read the first time. Now we come back second time. Now your basic is there. Then how do you answer opponent's pleading? What is it further and better particulars? Judgment in default defense. Remember in appearance or during the reading of statute, we briefly talk about JIDA. We briefly talk about JIT. This one, judgment in default or defense, is actually under Order 19. Order 19. Pleadings, it's under Order 18, Order 18, Order 18, Order 18, Order 18, Order 18. This one is Order 19. So I think it's much better I put it here. Okay, I put it here. Judgment in default or defense. And then after that, you have, can you raise an issue in trial if it's not pleaded? What about some exceptions where court allow party to raise a point even not pleaded? So if you see all these cases here, mainly you see 9.16, 9.16, the big bulk of case is around here. Okay? Actually, it's 9.1. Let me see. I think it should be 9.17, not 9.16. Maybe you can amend it. Okay. OCBC Philip Wee, Narayanand, both states, and Superintendent of Lands is 9.17. Sorry about that. Okay. OCBC Philip Wee, Superintendent, both state, Narayanand is 9.17. You can amend it a bit here. Alright, 9.17. But it's around there lah. It's all in the same area, these two. You look at these two together. Okay? You look at these two together. Then after that, we go amendments of pleading. So here, we will read the statute together. Now, what I will do is, what about the notes? Can you do any kind of notes? Okay? Now, let me show you. All right. So when it comes to pleading, you have rules. You can look at the notes. Okay, you have rules. Function of pleading, to me, is not that particularly important. You can have, number 1, rules of pleading. All right. Rules of pleading, they are mainly on the statute. Order 18, Rule 7 to Rule 12. Then after that, you have answering opponent's pleading. Answering opponent's pleading, not often tested, quite rare I should say. I've probably only seen it came out around 3 times, something like that, for the past 10 years. Alright, so if you don't want to make any notes in there, it's up to you. Okay, this, again, like I said, your main, it's your textbook. After that, I do 1 time for you. So now it's a 3rd time. So really, the really important one. The next one, really important one, is further and better particulars. This one, often tested. Okay? Often tested. After that, you have JIT. Judgment in default. The way you look at judgment in default is the same way you look at JIDA. When you read JIDA, like Order 13, you read it the same way as you read JIT. Okay, judgment in default or defense. And the last ones, all right, this is the ones on, can you raise an issue in the trial if it's not pleaded? Can you raise? So here you have list of cases. Together, you add on and then 1. What are the exceptions? So these are the ones that are commonly tested. So understand? Like that. Okay? Pleadings, I told function, I don't think there's a need to you, right? You just think of it whatever you know. Rules of pleading. Rules of pleading, actually, you don't even need to make any notes because it's all from your statute. Okay? It's all from your statute. After that, further and better particulars, there's a K, Datuk Seri Ling Yong Sik. And then JIT, there's not case, but it's just understanding again the statutes. So there's, to me, here, there's nothing to, no notes to make. To here, there's no notes to make. Here, these two is both about statutes. Okay, this both is about statutes. Further and better particulars, there's a case that you need. Here, there are a lot of cases and concepts. So if you look at all the cases that I give you today, they are mainly in that can you raise and what are the exceptions. Again, instead of giving you the summary, I think I just explain to you what are the things that you need. Okay, now let's dive in straight. Right, I want you to look at statute. Okay, let's read some statute before we go for a break. You look at Order 18. Okay, let's everyone flip to Order 18. Okay, this is the last time we read. So now we read for the second time. So you have a little bit better idea on it already. Okay, let's wipe it off again. Now, I didn't talk about Order 18, Rule 19 in your notes, even though it's under Order 18, because I put it under striking out under some speedy disposal. Okay? So we'll talk more about that, speedy disposal. Let's read some statute together. Okay, now let's start. Service of statement of claim. Okay. Unless the court give leave to the contrary, the statement of claim is endorsed on the writ and the plaintiff shall serve the statement of claim on the defendant, or if there are two or more defendants, on each defendant shall do so. I think it's quite general. Okay. When the writ served on defendant any time after service, but before the expiration of 14 days after the defendant entered appearance. So when do you need to serve statement of claims? Shall do so either when the writ is served on the defendant or any time after service of the writ, but before the expiration of 14 days after the defendant entered appearance. Most of the time, we serve the writ and statement of claim together. Sometimes we serve the writ without statement of claim because the statement of claim is not ready. Alright, then you have to look at this rule already. But before the expiration of 14 days, after the defendant, so you can serve the writ, the defendant can enter appearance first, later on you only serve statement of claim. Also can, it's up to you. But most of the time we writ and statement of claim is served together. What about defense? Okay, defense, these are all pleadings, right? Pleadings, that's why this is under pleadings. Subject to paragraph 2. A defendant who enters appearance and intends to defend shall, unless the court give leave to contrary, serve a defense on a plaintiff before expiration of 14 days after time limited for appearing statement of claim served on him, whichever is later. Okay, so depends, your statement of claim served later or appearance come later, 14 days after that. Right? In case you still confused, let's say it's like this, let's say. Okay, 1st of January, writ plus statement of claim. Then after that, you must enter appearance on 14, isn't it? After that, statement of defense. Who serves statement of defense? Defendants. Statement of defense. Okay, it's like that. Okay, you can. Service of reply and defense to counterclaim. A plaintiff on whom a defendant serve a defense shall serve a reply on a defendant if it is needed. Okay, if no reply is served, Rule 14 sub 1 shall apply. A plaintiff on whom a defendant serve a counterclaim shall, if it intends to defend it, serve on a defendant a defense to the counterclaim. So it will be plaintiff sue defendants. So plaintiff serve a statement of claim on his defendant already. Okay? But the defendant also counterclaim back against plaintiff. So now this guy become, suddenly in this counterclaim, this guy become plaintiff. Sorry. This guy becomes defendant. Because now you have a counterclaim. Okay, this one counterclaim. Alright? Shall, if he intends to defend it, serve on a defendant a defense. So the plaintiff now become a defendant in a counterclaim, serve a defense on the defendant. Where a plaintiff serve both reply and defense to a counterclaim on defendant, he shall include in the same document. Now you don't have to know in particular detail about this one. It's just the understanding. Now let me tell you some of the technical name in case you are interested to know, but not for your exam purposes. Okay, this is what it means. Alright. First, here, alright, here. Plaintiff sue defendant, right? Or Alex sue Mr. Lee. So the first thing plaintiff will send is statement of claim. Correct? After that, I use red color, which is defendant. He will send back a statement of defense. Okay? If the plaintiff won, plaintiff can send back a reply to defense. Alright? At the same time, at here, you can have a counterclaim. Okay? Counterclaim. Now, after this, alright, this is where is it? I think it's Order 20. Let me get you the technical term. These are not tested for you in exam, but in case you wanted to know. Okay, what are the technical terms? They are very technical terms. Okay. Here. Here. You see here? Pleading subsequent to a reply of defense shall not be served except with the leave of the court, means you need permission. So the standard is here. After here, if you wanted to serve some more to each other, then you will need a permission from the court. So what's the next one? The next one, okay, it's by the defendant, because red color is defendant, blue color is plaintiff. If the defendant want to continue, they will do something called rejoinder. So first, plaintiff sends statement of claim, then defendant sends statement of defense. Then after that, if the plaintiff want to reply, can, or at the same time here, you can have counterclaim. Normally, you stop there. After that, if defendant wanted to reply, it's something called a rejoinder. After rejoinder, then plaintiff want to reply back again, like ding dong, ding dong. It's called sure joinder. Okay, sure joinder. Blue color is by plaintiff, red is by defendant. After that, you still want some more? Can. It's something we call rebuttal. And after that, it's called Sure butter. Okay, that is just a technical term if you want to know. All right, not particular for your exam. So this is here the Order 18 Rule 3 and Rule 4. All right. Now Order 18 Rule 6. But just now when I say your rules of pleading, it's under Order 18 Rule 7 to Rule 12. Rule 6 is much more to the technical things on your pleading. Your pleading need to be numbered, paragraph, line up like this. The rules is what are the things you can write and cannot write in pleading. So this is also same like as in your statement of claim that we have done. Okay, the statement of claim in your contract and tort, it's pleading. So when you draft your statement of claim, what are the things that you can write and you cannot write that is under your rules of pleading 7 to 12. 6, it's about, okay, it shall have bear this, all right. Okay, this one. Okay, you won't be tested anyone, you can read this on your own. So Rule 7 to Rule 12, that is your rules. Okay? So now we take a break first. We come back, we do rules. You can also look at the notes on rules. All right? right, let's continue reading. Facts not evident to be pleaded. So we'll read first and then we'll go to the notes. And then it says subject, every pleading shall contain only a statement in the summary form, material facts, defense, but not the evidence. That is why in your statement of claim in contract and tort, we don't plead evidence, we only plead facts. You don't say what law. You only say what happened. That's it. Okay? If material be briefly stated, precise words, okay, of the document conversation shall not be stated except insofar as those words are themselves material. So the key word is here. You see the keywords? Material facts, not evidence. Material. Okay. Then, what are the things you shall specifically plead? Performance. This one. Yeah. Performance, release any relevant statute of limitation. That's why in the first class of limitation, we say limitation must be expressly pleaded if you wanted to rely on it. What case? Tasja and golden approach. Fraud, illegality. Okay, you must particularly plead all these things. Okay, then you read here, alleged make claims, if not pleaded, might take the opposite party by surprise, which raises issue of fact not arising out of the proceeding. Departure. A party shall not in pleading make an allegation of fact or raise any new ground inconsistent with a previous pleading. So you can only raise things that you have pleaded. Okay, you can only raise things that you have pleaded. If you don't write it down in your pleading, generally you cannot raise it. Points of law may be pleaded. A party may be pleading raise any points of law. Now we talk about this later on. Okay, general rule, you only plead evidence, facts. All right. Then particulars of pleading. Every pleading shall contain necessary particular, defense without prejudice, misrep, fraud, breach. Okay, all these things. Then here. No party shall quantify, claim, or counter-claim for general damages. That is why also in your statement of claim, you don't plead general damages. You just write damages because it's up to the registrar or judge to assess it. However, if it's specific damage, you must plead it. All right? Okay, you can read this one on your own. Sorry. Okay, admission or denial. This is how you answer opponent's pleading. So when Alex sent a statement of claim to Mr. Lee, how Mr. Lee gonna answer the statement of claim? Mr. Lee gonna send back a statement of defense. What is he gonna write? Okay, and there is a term we call traverse. Traverse. A traverse may be either by denial or by a statement of non-admission or expressly. So when Alex sent a statement of claim to Mr. Lee has to deny every single thing that Alex said. If he don't, it will amount to as if Mr. Lee admit to it. So this is in general how? In each statement, Mr. Lee must deny, or there's a general denial at the end of the statement of defense. Okay, and I'll give you a few cases there. Sabah, whatever. Later we look at it together. Okay, next one. Now, this is a statement of claim. Okay, we will not read striking out because we'll do this when we do speedy disposal. Okay, I'll leave this out first because there's some cases there. So when is close of pleading? So you need to know about this. So sometimes in exam you need to look at it because later on when we do amendment of pleading, you will need to look at this close of pleading. So at least you know what is it about. So let's see. Let's give you an example. Let me use this example. It's a good one. Okay. Now let's say here. values here. All right. Let's say 1st of March 2025. Sorry, not 1st of March, not 1st of January. 1st of March 2025. Read plus statement of claim sent. Okay, sorry, read and statement of claim filed, let's say here. Let's do this. Read plus statement of claim filed. And on the 10th of March, read plus statement of claim serve. Okay, serve. All right, serve. So when must you enter appearance? What is the rule on appearance? Order 12. Now let's look at your order 12. Time limited for appearing. In the case of writ served within Peninsula, 14 days after service of the writ or whether time expended. So the due date for Mr. Lee to enter appearance is 10th of March plus 14 days. That's the due date. Okay, from the day when you serve, when he has been served. So let's assume 15 March. Mr. Lee filed appearance. Okay, let's see. When is the due date? All right. What do you call that? Mr. Lee must send back a statement of defense. Then you look at your order 18. Look at order 18, statement of defense went. Service of defense. Order 18 Rule 2. Subject to a paragraph, a defendant who enters appearance and intends to defend shall, unless the court give leave, serve a defense on a plaintiff before expiration of 14 days after time limited for appearing. So 15 plus 14, that is a due date. Okay, that is a due date. And let's say he served, so he memang serve it on this date, 29th of March. Statement of defense served. Okay, or file statement of defense. Okay, serve and file statement of defense. So when is it pleading close? So now you look at your order 18 Rule 20. The pleading in an action here are deemed to be closed at the expiration 14 days after service of reply. What is service of reply? Service of reply, it's here. This one. Service of reply. Okay, 14 days after service of reply. Or if there is no reply, but only a defense or counterclaim after service of the defense or counterclaim. If let's say there is a counterclaim here. What if no reply and no counterclaim? Basic statement of claim, statement of defense. Then you see B. If neither a reply nor a defense to a counterclaim is served, expiration of 14 days after service of defense. That is your order 18 Rule 20. Here. So assuming here, statement of defense served, no reply, no counterclaim. When is pleading deemed to be closed? It deemed to be closed on th of April. Okay, that is a simple timeline example for you, so that it works. So that you need to know when is it closed. You will need to know when is it closed, so that when you do amendment of pleading, you know. All right. And you also have trial without pleading. When an action Which rule applies to defendant has entered plaintiff defendant and may apply the court by notice of application order the action be tried without pleading case. Okay, you can read this on your own. Then after that. Okay, now let's look at the notes. Let's look at the notes. So function of pleading, I think I don't want to explain much. So basically it's just very general. The pleading is to inform the other party what they want to sue. It's also to define the issue. It's also to save time, so the judge know what is it that you all wanted to do. So you don't have to, there are a lot of books, or you can even use Google to find your answer. So you don't have to particularly memorize word by word. You don't have to. Okay, please don't be so rigid in the way you study. Don't be rigid. Okay, sometimes I find students so rigid. They must memorize every single word. If they don't, they feel like nervous. Don't have to. Sometimes you do get a question, just answer whatever you know. There is no like fixed answer to it. Then after that, you have rules of pleading. So you see, when just now, plead material facts, not evidence. Why? Material facts is essential facts required to establish a cause of action. So sometimes you get 6-7 marks question on rules of pleading. Then you have to talk about Order 18, Rule 7 to Rule 12. What is the purpose? Inform what the case. So for example, defendant failed to deliver the goods as agreed. Defendant driver admitted that the lorry had broken down. Okay, so defendant failed. Facts. The rule draws a clear line between pleading facts and proving facts. Pleading tell the story. Courts have repeated stress as to prevent. So you don't go and analyze the fact. It is for the judge to analyze the fact. You only write down what the facts. In Re Estate and Lee Xiao Q, you can quote this case. The meaning of material facts is explained in the often cited passage of this Cotton, LG, and Phillips. The pleading should state those facts which would put the defendant on their guard and tell them what they have to meet. One has in these cases to consider what's the party pleading set out to prove. Then one has to consider whether it has been set out with sufficient precision. The parties by their pleadings define the issue which the court will have ultimately to decide. If you want, okay, you can use some keywords in there so that when there is a question of material facts, you can quote this case, often quoted case, Re Estate Lee Xiao Kiao or Phillips and Phillips. What is the meaning of material facts? Rule 8, we talk about it, specifically pleaded, no surprise. Rule 9, state of mind. Allegations involving intent, malice may be pleaded generally. However, the court can order particulars be supplied if needed because the state of mind is hard to prove. Okay, it's general. Rule 10, denial of contract, custom. A general denial is not enough. Pleader must specifically deny or state their version. Stop evasive denial. If you say, I never contracted, you must say why. I never signed, the person had no authority. So it's not off. I mean, in practical scenario, it's not often we have to go until this part, state of mind. Where very often is just this 7 and 8. Okay, the particular pleadings that we plead. And Rule 12, Rule 11, a party may raise point of law. The court may dispose the matter without full trial if the point is decisive. This allows early disposal. Limitation, no cause of action. Okay, point of law. You don't analyze law, you raise it. And Rule 12, every pleading must include necessary particulars sufficient to make it intelligible. So what is it? Fraud, misrep. Okay, and say no need to quantify general damages. Okay, so answering opponent's pleading that is under your Order 18 Rule 13, and the keyword I say is traverse. Okay, let's come here because there are two cases I want to look at it. Any allegation of fact is deemed admitted unless specifically denied. So when Alex sent a statement of claim to Mr. Lee has to specifically deny it. If he don't, it will as if that Mr. Lee admit to those facts. So a general denial is not sufficient. Each material allegation must be specifically addressed. So for example, Alex sent to Mr. Lee, point number 1, Mr. Lee, you do this. Point number 2, Mr. Lee, you do this. In Mr. Lee's statement of defense, Mr. Lee must say, point number 1, I deny. Point number 2, I deny. Point number 3, I deny. So general rule is that kind of thingy. Okay? So there are a few kinds of type of traverse. Number 1, specific denial. Directly contradicts the fact. Denied. Mr. Lee, you took 40,000 from me, but you didn't send a stock. Okay, Alex, I deny because I sent a stock and I didn't take. So it's directly denied, specific denial. Or non-admission, state lack of knowledge, whatever, treated as denial. Or a general traverse. Most of the time, you see at a statement of defense, whatever, at the end of the statement of defense, the particular defendant will put like a clause, like a round up clause, a blanket denial. It says like this. Save as admitted, the defendant deny each and every allegation. Can or not? Can. Also can. So it's either you go into each one by one, deny, or you go just at the end, one thing, one shot, deny every single thing. Can. Okay? So you can read the effect. So there are two cases you can use. Simon Umar, that's why you see I give you the case here also. Simon Umar, okay? And I tell you where about to read. If you want, if you can, please read it. But for this particular chapter, I go further for you. So I do it. These two cases actually are still okay. It's the part on the plead material facts I wanted to go through with you. Plaintiff used a general traverse, deny each and every allegation. Later, he tried to argue a different position, claiming an investigation committee existed when his pleading had denied it. So plaintiff already general traverse and said, no, I deny. Later on, he kind of find that he missed out. He actually wanted to say that this investigation committee existed, but he already general traverse. So then if he said this existed, will contradict. So parties are bound by the pleadings. General traverse operate as a denial. Since the plaintiff denied existence, he couldn't later assert the opposite. Federal court rejected. So general traverse, as in like this, works. Next one is this case of Sabah Land. The defendant's defense most like general denial without specific traverse. Okay, the alleged invoices, court held this is insufficient. General denial is not proper traverse for material allegation. Defendant must specifically admit, deny, failure, traverse, deem, pleading must split with point substance. So when it comes to here, it's either it's generally we go like this specific denial. Or if you want to go general traverse, you must write as in like this, deny each and every allegation. So everything you say deny. So you cannot as too general. So if it's too general, you didn't really write it properly, it's not enough denial. So that is what this case says of Sabah Land development. I think you see here. What paragraph I want you to read? Para 22. Okay, you can read this one, please. You see there? It's common practice to end defense with a statement, save in herein before specially admitted. The defendant deny each and every allegation contained in the statement as though same was set out herein in traverse. This practice is convenient dealing with long and complicated and immaterial allegations. However, it should not be adopted in dealing with essential allegation. So that's why I write here. You see here? Denies all allegation but may be inadequate if used for key facts. So most of the time in practical scenario, we go by this way. So this one is useful for a very long one, but then if there's really key facts, it's much better that we go this way. Okay? It's not often you get question in exam. I only see it 2 or 3 times only. You get this part. Right, what about further and better particulars? Further and better particulars works for, this is under your Order 18 Rule. Order 18 Rule 12. Okay, you can open up on your Order 18 Rule 12 and we read it together. Further and better particulars, it means that when the plaintiff sent a statement of claim to the defendant read it, unsure, he wanted clarification from the plaintiff, then the defendant can do something and ask the plaintiff for more information. It can also work where defendant sent a statement of defense to plaintiff. Plaintiff read it unsure, then plaintiff call the defendant, ask for more information. So it can work for plaintiff defendant. It's just a general rule on pleading. Further and better particulars, what is it? What's the general principle? Very often come up in exam, this one. Ensure clarity, fairness, prevent surprise. Okay, sometimes they ask you general principles. Again, you just write on your own. Now, there is a case that you need to know, which is the case of Datuk Seri Ling Leong Sing and Krishna Kumar. I think I only want you to read one paragraph, which is paragraph 5 or whole case. Okay, if you can read the whole case because it may need to incorporate some of your other knowledge. If you cannot, then you just read paragraph 5. Paragraph 5 is here. Okay, principal governing. Now, in Datuk Seri Ling Leong Sing, okay, let's read this case instead of relying on the summary I give you. At the outset, it is necessary to state the functions of particulars. This is comprehensively set up. The functions of particular means the functions of the things in your pleading. Okay, those written down. Is to inform the other side of the nature of the case, that they have to meet as distinguished from the mode in what the case in the proof, to prevent the other side from being taken by surprise at the trial. So, when plaintiff sent a statement of claim to Mr. Lee wanted better particulars because they are unsure. So that's why he wanted to ask you so that to prevent later on surprise or this thing. To enable the other side to know what evidence they ought to be prepared and prepare. To limit the generality, too general cannot, or the claim or the evidence. To limit or define the issues, at least your statement of claim, statement of defense, we know what is it that we disagree, we can argue about, as to which discovery is required. To tie the hands of the party, so he cannot go without leave, go into any matters not included. Because you can only raise things you write in your pleading, regardless of plaintiff or defendant. So those things that you didn't write in there, you cannot later raise it in trial. So you are bound by always we call four corners, because the paper is four corners. Okay? So if you can, you read the case. So when it comes to further and better particulars, you can, plaintiff send a statement of claim to the other party, all right, and then the defendant wanted, so then defendant can ask more information from the Alex because he wanted to prevent surprise, inform, all these things. But there are also some other principles and procedure that you will need to know because they will test you on the procedure. Number one, now I want you to look at your Order 18 Rule 12. Let's look at your Order 18 Rule 12 first. Order 18 Rule 12, Sub 3. The court may order a party to serve on any other party particulars of claim, defense, matters stated, pleading, and an affidavit of his to stand pleading statement, which he relies, and an order may be made on such term as the court think just. Then you say, Sub 6. Where the applicant for an order under this rule did not apply by letter for the particulars required, the court may refuse to make an order unless the court is of the opinion there were sufficient reasons for an application by letter not having been made. Okay, now come back to the notes. First step, you cannot go straight to the court and ask the court to help you. You must do something. You can request by letter. You can call the other side. Normally we call now. Because most of the time in practical, when you got something that you're unsure of, you just call the other lawyer, then they'll explain that it's settled, soft. Okay, the much more proper is to send a letter, write to the other side asking for further. If the request is ignored, then only you can go to the court. If no letter was sent, the court may refuse because Order 18 Rule 12, is it sub 5 or sub 6? Sorry, this is sub 6. Okay? Sorry. Correct. Special reason sub 5. Okay, sub 5. Correct. This is correct. So you must call first, or you must send a letter first. If the other party don't want to lion you, then only you go to the court and ask the court for help. Then notice of application, support by affidavit. But affidavit is not mandatory in here. Okay, affidavit is not mandatory because there's a case, and a case you can quote is crying and MBP capital. While affidavit is useful, it's not universal. Then after that is the court discretion. Court granting discretionary power, ensure party reasonably informed, the court balance between providing clarity and avoid fishing expedition. So if you look at here, the general principle when it comes to pleading, it's about this one, Datuk Seri Ling Dong Sik case, to inform the other party. So you cannot have Alex sending a statement of claim to Mr. Lee, and Mr. Lee because he wanted to fish for evidence. Sometimes we use this term, fish, F-I-S-H, fish for evidence, like fishing. It's like using a further and better particulars, try to go and correct what's Alex evidence he gonna use. So the court wouldn't allow you to do that. Fishing expedition. That's it. Fishing for evidence. Generally, such requests cannot be made before defense is served. Okay? Exception may allow. So this is your procedure and very often tested, and you need to know this case, further and better particulars. Now, let's look at judgment in default of defense. So let's look at your Order 19. If you see your Order 19 here, which I share for you on the screen, and you open up on your Order 13, default appearance to reads, correct? It's the same thing. Now, you see here, default in service of statement of claim. This one is not really particularly relevant for here. So if you know the other party already served you a writ, but still don't serve you a statement of claim, now out of the particular time, you can apply to dismiss the action. Sorry. Then you see here, liquidated demand. That is similar to your Order 13, Rule 1. Similar. Everything is similar. Then you have unliquidated demands. That is similar to your Order 13, Rule 2. Then you have detenues. Similar to Order 13, Rule 3. And then defense. Possession for immovable. Order 13, Rule 4, isn't it? Rule 4. Okay, you have mixed claim. Mixed claim, Order 13, Rule 5. And then you have other claim. This one, similar to Order 13, Rule 6. But that kind of specific performance, all these things, is not relevant here. Now, let's go to this one. Okay, also you have this thing, same, you see that? Setting aside. Why? Because this is judgment without merits. And the principles, evens and bedlams, all these things are the same. Now, let's look at here. If you see here, okay, we discussed this, isn't it? So this one, Order 13, Rule 1, final judgment. If you look at your Order 19, Order 19, Rule 2, okay, also final judgment. This one, Order 13, Rule 2, unliquidated demand is interlocutory. So your Order 19, Rule 3, also interlocutory, meaning they have to send it to assess damages pursuant to sex. So same thing, everything's the same. But the procedure is slightly different. Now, if you look at here, Order 13, Rule 6 here, which categories claims under here, rescission, seeking, this is assess, this thing will not be in your Order 19, Rule 7. Okay? These things are not in your Order 19, Rule 7. So we have the procedure here. This is your judgment in default of appearance. So much more complicated, not more complicated, much more forms. And then you have this setting aside, isn't it? Setting aside time, delay, all these things. The type of judgment, irregular, regular. This one, evens and bottom. Same for JIT. Same. Everything is the same for JIT. Okay? Now, if you come back here. Alright. Now, let's come through here. And then I'll explain to you. Procedure 1. What's the procedure? First step. So again, okay, maybe I draw it out to you. Much better. So Alex sue Mr. Lee. Correct? And okay. First, writ and statement of claims. So on 14th, if Alex didn't enter appearance, here, if Mr. Lee didn't enter appearance, Alex will get a JIDA, isn't it? But I also said there are certain things where even if Mr. Lee didn't enter appearance, Alex cannot get a JIDA. So those are the things listed under your Order 13 rule. Rule 6 or Rule 7? I always confuse. Rule 6, isn't it? So for those kind of things, you must continue. For example, specific performance, rescission, accounting. Then you must continue as if that Mr. Lee has entered appearance. Then you continue lah. Okay? Continue. So next date is this one. Under this one, Mr. Lee must send a statement of defense. In here, if Mr. Lee didn't send a statement of defense, then Alex can get a JIT, judgment in default of defense. These two are final, depends whether it's final interlocutory. It's like a judgment after trial, okay? Same. It's just that some it's final, some it's interlocutory, depending, because you need to assess the damages by how? Order 37, isn't it? Okay? And because this is not, it is a judgment without merit. Why is it without merit? Because the judge didn't listen to the case. Alex got the judgment because Mr. Lee didn't follow particular procedure. So that's why you will have something like Order 13 Rule 8 or Order 19 Rule 9. Rule 9, where it allows Mr. Lee to set it aside, isn't it? And you have evens and bottoms, all this irregularity, what we have discussed in appearance. Okay, same principle. Now, sometimes students confuse as if this thing only apply in those kind of situation like specific performance, rescission. No. Let's say like this. Let's say Alex sue Mr. Lee for breach of contract. General thing. Breach of contract. If on 14th, Mr. Lee didn't enter appearance, then Alex will get a JIDA. Settled. Let's say Mr. Lee did enter appearance. Okay, so no issue here. Then continue. And of 28, Alex sued Mr. Lee for breach of contract. Mr. Lee didn't send a statement of defense, then you get a JIT. So JIDA and JIT work for everything. It's just that on this particular JIDA, there is one specific thing that is under your Order 13 Rule 6, where that kind of field thingy, even if the party didn't enter appearance, you cannot enter a JIDA against him. So you have to continue and as if he has entered appearance, and then you will go to the next step. And let's say again, Let's say, now, Alex sued Mr. Lee for specific performance. And on this particular date, Mr. Lee didn't enter appearance. Can Alex enter JIDA? Cannot, because this is classified under Order 13 Rule 6, isn't it? Things that you cannot enter JIDA. So Alex will continue the case and wait until 28. If on 28, Mr. Lee did send statement of defense to Alex, then what's next? Go to trial. That's it. As usual, go to trial process. Okay, that's how it works. Now, come back to your notes. Okay, appearance entered, no defense served. So I write out procedure for you. If it's liquidated, file request for entry of final, proof of service or statement of claim, certificate that no defense was filed, and then 2 final judgment form. So your judgment form is Y75A. You look at form 75 at the back. Okay, you look at form 75 at the back. Why I use A? Because A is for liquidated, isn't it? Okay. A is for liquidated. This one same thing, B. This one same thing, C. And this one immovable. Then slightly different. If you look at the Order 19 Rule 5, solicitors certificates. Where do I get this from? This is from your Order 19 Rule 5. Affidavits, you don't have to memorize, just where is it? From your Order 19 Rule 5. Form 75D. Other claim, then why do I use notice of application? Because it is stated there, Order 19 Rule 7. Order 19 says Rule 7, statement of claim plus affidavit verifying default. Okay? Right, so that's it for your JIT. So now we come to the one often tested. Can you raise an issue in trial if it's not pleaded? Why is it some typo error here? Sorry. Alright, just ignore me. Okay, so these are all the cases in there. But I didn't give you the summary because I want you, but I tell you which about for you to read, isn't it? So if you can, please read it. But I go through here for you. What time is it now? Should we go for a break or not? Okay, we still got time. Okay, let's start first. The general rule is that you cannot raise an issue in trial if it's not pleaded. So now you know the meaning of plead. Plead is to write it in your statement of claim or statement of defense, regardless of plaintiff or defendant. You can only raise the thing in trial as evidence. Say judge, whatever, if in the beginning you put it in the statement of claim or statement of defense. Now again, have that idea here. You see, 7 block, isn't it? So now you know who to sue everything. So in your pleading, you must write the things correctly. Because if you don't write this thing correctly, later on you go down to trial. Here trial, you cannot raise it. So here in the beginning, we must get all these things right. You must write the correct things. So that only then in later on in the trial, we can raise this thing up. Okay? So the first one, you always go. Now, so many cases here, but the often quoted cases in judges or in cases is Janaki and Ong Kiat and also Wisma Punca Emas. These are the 2 common cases, but I give you more because I wanted to explain. You can also quote Lee Ah Chaw. Okay, now let's look at it. In Janaki and Ong Kiat, plaintiff sued for repayment of loan. Defendant denied borrowing but said he took the loan from someone else. Magistrate dismissed the claim, holding the note invalid because the defendant was illiterate and plaintiff had not complied with this, even though no such plea was raised in the defense. Held. The trial must confine. Magistrate was wrong on deciding a point not pleaded. A judgment should be based upon issue which arise in a suit. It is not for the court to displace the case made by a party in its pleading and give effect. So the judge can only and will only look at what you plead on your defense, on your claim. Okay? Cases must be decided on record. If other issues to raise, they must be placed. So general rule, Janaki and Ong Kiat. Wisma Punca Emas. Plaintiff sued the defendant, developer, for damage to his clinic allegedly caused by excavation next door. His statement of claim alleged negligent excavation and removal of earth. Earth is the tanah, okay, tanah. At trial, the judge found the defendant liable for nuisance, even though nuisance was never pleaded, because plaintiff pleads negligent. Judge say defendant are liable for nuisance, but plaintiff pleads negligent. Can or cannot? On appeal, the defendant argued he was taken by surprise. Because why? Datuk Seri Lim Leong Sik, all this case, you must plead it or else are taken by surprise. He defended a case of negligence and not nuisance. Defendant say, I argue and defend my defense on saying I'm not negligent. How come, judge, you say nuisance? However, this judge decide differently. He said, even though nuisance was not pleaded, the word nuisance was not pleaded, but the facts that give rise to negligence did give rise to nuisance as well. It doesn't prejudice you, defendant. You see here, the cause of action was clear. The failure to yield the words did not prejudice. It is only this word that he didn't plead. But the facts is the same. If you say a totally complete different fact, then okay, cannot. But it is the same fact. Everything same. It's just the word nuisance you didn't plead. It didn't prejudice you. It didn't, bring you by surprise. Since the evidence and defense addressed the same facts, the claim in substance was within the pleading. Judgment upheld. So this is dissent. What is dissent? Dissenting means disagree. This judge disagreed. Stress that fair notice. You can read this on your own, and I give you the whole case I want you to read as well if you can. Okay? Wisma Punca Emas. This one. Very short case. Okay, very short case. State of Government Munyandi. Plaintiff sued for damages for wrongful act committed by government servant. The state government attempted to rely on an unpleaded administrative circular to deny liability. The federal court held state was bound. It could not introduce new justification. Okay? Lia Chaw. The borrower appealed on new arguments not raised in High Court, such as validity of the bank demand notice and computation. Bank objected that these were never pleaded or argued below. Argued below is what? Because this case go to the Court of Appeal. It was never pleaded or argued below in the High Court. Supreme Court rejected the new points. I think it was Supreme Court. Okay, meaning never argued below in the Court of Appeal, High Court. Where a vital issue was not raised in pleading, it could not be allowed to be argued and succeed on appeal. It was never raised in the pleading. It was never being argued in the lower court. So now you go to Supreme Court or whatever court of appeal, you cannot raise it. You also see in this case, Chartered Bank and Yong Chan. Reliance upon pleadings is not pedantry. It is essential, meaning it's a definite requirement. Okay? I also told you which particular page you can read. It's quite good case, this Lia Chaw. This is para 12 to 16. Okay? If you can, please, so that you can understand what is it about that I wanted to show you. So I already do a lot of front work for you, summarize things, so you already look at it. If you want, you can look at the whole case, okay? You see they quoted Janagi and Ong Boon Kiat, Chartered Bank, all these things. All right? Now, however, as always the law, we have some exceptions. There are certain exceptions whereby even if you don't raise it, even if you don't plead it, the court say it's okay. We will take it into consideration. Okay? I think we can take a break now. We take a break now, you look at this few cases, we finish off, then after that, we go to amendment. Okay? Amendment, there are some cases also I want to read with you. Okay? Let's take a break. Alright, let's continue. Okay. There are some exceptions where the court will allow. And the very common case you see is this OCBC, Overseas Chinese Banking, against Philip Wee. So the bank sued the borrower for debt. Borrower raised limitation. Okay. During the trial, the bank produced a letter from the borrower acknowledging the debt. But this acknowledgement was never pleaded in the statement of claim. Because if you look at this one, OCBC, Philip Wee. Limitation, okay, section 6. And you have section 26 sub 2. Remember this one? Where if you text someone the owe you debt after limitation, he say, okay, I remember, then the time starts to run again. Remember that section 26? So this is what happened. The borrower raised limitation as a defense and say, hey, bank, you cannot sue me. The bank said, no, you did acknowledge and say that you owe me. So time restart again. So then, but this thing was never pleaded in a statement of claim. The defense should have objected when the plaintiff raised this thing, but he didn't object. So even though the acknowledgement was not pleaded, once it was admitted in evidence without objection, it became part of the record. The court could rely on it to find that the debt was revived and not time-barred. So what it says here, when the other bank raised this thing, you didn't object. You allow the bank to continue. You even argue and debate on it. So you cannot later come on and say you are taken by surprise or prejudice. So I put in some analysis here. Waiver principle, opposing party fails to object, the court may consider issue based on. It also highlights the modern pragmatic approach pleadings are meant to prevent. So it didn't bring you by surprise because you argue whatever. You cannot later on and say, oh, sorry, I didn't know. You should have objected at the time. You didn't object. You let it raise. Okay? Narayanand. Plaintiff sought vacant possession based on deed of gift. Defendant never pleaded illegality. But the deed was void under National Land Code, your land. Even though illegality was not pleaded, the court would not enforce an illegal transaction, illegal contract. These represent public policy. Illegality cannot be ignored because it was unpleaded. Okay? Illegality, the court will not give rise to illegal contract. Both states, Arab Malaysian Finance. The appellant purchased goods on credit from Chemitrade. Chemitrade entered into an agreement with Arab Malaysian Finance and they have this particular clause. Offset clause, we call it offset clause. It's much more to contract and commercial. Both states paid several invoices without protest but later refused, claiming an offset clause. AMB sued for payment. Both states contended the bank could not rely on estoppel as it has not pleaded it. Estoppel must be specifically pleaded. Okay, this provision requires pleading. Okay, however, the federal court clarified it's not fatal if the word estoppel itself is not used. What matters is whether the material facts giving rise to estoppel are sufficiently pleaded. Almost the same thing like your Wisma Punca Emas case. Okay, court may still allow unpleaded estoppel to be argued in the interest of justice. So this one, it's almost the same like your Wisma Punca Emas. Even though this is not pleaded, recognized exceptions, a court can depart if no prejudice or surprise. If our material facts were ventilated, arguments were directed, justice required consideration on the facts, both that are acted unconscionably. They keep continuing to pay, okay, they'll do this, so they cannot later say that by surprise. Not often you see, okay, if you wanted to quote this case, you must be well versed in the facts. Okay, you must be well versed in the facts. So the one that we often do quote is overseas. But of course, in an exam, they won't ask you what are the exceptions. You have to look at the fact itself. What is it that you think you can apply here? Which one the case that you think you can apply? Okay, there's one more case I want you to know. This one. And I want you to read the case if you can. Alright? Because they talk about this radical departure. Plaintiff claimed native customary right over land in Miri. Defendant denied in their defense but gave no reasons. During the trial, they introduced new factual reasons that the land was within a riverbank and no title could be claimed, and once belonged to Sarawak Shell. Plaintiff did not object when this evidence was led. They waited until final submission to argue it should be excluded because it was not pleaded. So they said, defendant, you cannot rely because you didn't plead. These new matters were indeed material facts that ought to be pleaded. Defendant, you should plead. However, because the plaintiff did not object when the evidence was introduced, the defect was waived. OCBC Philip Wee. Okay? Evidence, then they go on, this judge, Pei Swee Chin is a very famous judge. Evidence admitted without timely objection can cure the defect of pleading unless it amounts to a radical departure from pleaded case. So this first sentence says that if you didn't plead something, you raise and the other party didn't object, yet further go and argue whatever with you, the other party later cannot go and say that, hey, I'm taken by surprise. So that's why evidence admitted without objection can cure the defect even though the defendant didn't plead it. However, there is also one exception. If the evidence the defendant raised amounts to a radical departure from the pleaded case, even if it's not pleaded, then it was raised, defendant didn't object, defendant argue on it, later on, defendant defendant still cannot say that, hey, plaintiff, we argue already, so you cannot object. Because what the defendant is raising here is a radical departure. Now again, I explained. OCBC Philip Wee says that if one party didn't plead it, he raised it, you should have object. You didn't object, you allow it to be continued, articulate, you allow the evidence to be pleaded, raised, you argue with it. You cannot later on argue and say, defendant, you didn't plead, so that's why you cannot rely on it. Because you argued that thing on trial. You are not taken by surprise. Same thing, this is what Pei Swee Chin said. But Pei Swee Chin also said that, again, let's say plaintiff and defendant. Defendant raised certain things. Plaintiff didn't object. Plaintiff argued whatever the evidence in trial. So, based on OCBC Philip Wee, plaintiff, you cannot later object and say, defendant, you didn't plead and taken by surprise. OCBC Philip Wee. But then Pei Swee Chin said, okay, there is another possibility where plaintiff, you may object. Meaning, defendant, you raised something, plaintiff, you didn't object, you argued, okay? Later on, this thing still cannot be admitted when the evidence that is raised by the defendant, where it was not pleaded, where it was fully argued by both parties, that evidence amounts to a radical departure. Since the defendant evidence was only a mere development was what already pleaded, the court allowed it. So what is radical departure? So I want you to read the case because that's the reason why I didn't give you a summary. I want you to go through the case with you. Because I think if I leave it to you, every one of you will come out with different answers. Radical departure, Pei Swee Chin, he go further analyze it. The exception is when such evidence represents an radical departure from pleading, not just variation, modification, development. This means if the evidence completely changes the nature of the case, introducing a new defense, new cause of action. Okay? So example how? The evidence bearing on two alleged defense is not such radical but mere development. The defendant pleaded position was, we deny the plaintiff native customary right. Their trial evidence gave reason. It was seen as consistent even though it was not pleaded. Okay? Thus, it was a development of the pleaded case, not a new or inconsistent, even though this was not pleaded, but it doesn't amount to a radical departure. What is it that is radical? And he gave example. If the defendant had mid-trial introduced completely new legal justification, that the plaintiff title was forfeited, okay, then you change the whole cause. Such a shift would be radical departure, cannot be allowed. Even this thing, let's say this thing was raised by defendant. Plaintiff argue whatever, okay, didn't object. Later on, the court also will not allow this to be admitted. They will not allow you to rely on OCBC Philip Wee because this amounts to a radical departure. So, they use a few examples. Plaintiff pleaded she was walking along the proper side of the road, but in evidence she was crossing the road. This was not fatal because both versions deal with the same incident. No surprise. This is not a radical. Radical is totally different. So I want you to know. So when you read cases as a lawyer, now you are a fourth year student. you are expected to go further, not just the first, second, third year, that kind of very general. You have to go into the facts. So because when you're in a practical scenario in a lawyer, you have to not just differentiate, you can go one step further down. Because sometimes you see lawyers in courts, the way they argue is so general, it lacks substance. So they want you to have that substance in there. Okay? So take note of all these things. Now, let's move on to this principle. Under principle, I also wanted to read the statute with you. Okay? But if you look at principle, there are a few things. What is it, the notes that you can make if you want? Okay? Principles. Principles of amendment, it's under Order 20. Now, to me, there is no need to make notes about Order 20 because it's all in your statute. Learn to read statute. But there are a few things in there you will need to know. Okay? There are some principles of amendments where I give you 4 cases and I want you to know this case. Out of these 4 cases, I didn't give you any Clarapit Commercial Union, Malayan Banking Ting Yin Yang, or even Yamaha, but I gave you the case of Hong Leong Finance Lo Tiam Ho, and I hope that you go and read it. Okay, so there are 4 cases here. Cases, and these are principles. It's important in your exam, so you have to state these principles. So principles. Second, there are certain instances, and I think there are about 7 I named here, where amendment not allowed. These are very academic, but you also need to know because sometimes you get asked in exam as well. Amendment not allowed. And last is something we call doctrine of relation back. This is under your Order 20 Rule 5. And to me, there's one case here, but to me, there's nothing much. It's all statute based. Here you have some cases. Okay, here is just some scenario, some cases like Kyormaru. So you just need to know. Okay, to me, it's quite straightforward for this part. Now, let's look at your statute. Let's look at Order 20. And let's read it together. We have read it before, so let's read it again. Okay, so now we read for the second time already. So by right, you should have much better understanding now already. All right, okay. Now, first one. Amendment of writ without leave. Take note, this is writs. Meaning, you can amend the writ without permission of the court. When can you do so? Subject to paragraph 3, the plaintiff. Why plaintiff? Because the defendant won't send a writ, isn't it? It is always the plaintiff that send the writ or OS to the defendant. Okay? So I think now you all know this one. The plaintiff may, without leave of the court, amend the writ once at any time before the pleading action begin and by writ are deemed to be closed. So now you said no, when is it deemed to be closed, isn't it? Order 18 Rule 20. So just now I give you all the example. So you can amend the writ once before the pleading close. So if you amend once already, okay, before pleading close, but now you want to amend second time, how? Then you will need a leave. Then you will need permission. If you wanted to amend the writ after the pleading close, then how? Then you will need a leave. And when we say need a leave, which particular order are we looking at? Then you look at Order 20 Rule 5. Because why? Order 20 Rule 5, it's your amendment of writ or pleading with leave. Particular, Order 20 Rule 5 sub 1. Okay, next. Where a writ is amended under this rule after service, then unless the court otherwise direct on application made ex parte, amended writ shall be served. Okay, very general. This rule shall not apply to relation to an amendment which consists of addition, omission, substitution of the party, or alteration of capacity in which a party action sues. Addition, add on a co-defendant. Omission, remove a defendant. Substitution, Alex become Jamie. Or alteration capacity, okay, in which a party sues. For example, Alex is suing as a defendant. Suddenly, Alex wants to change to sue as an administrator. Or addition, substitution of new cause of action. Cause of action is under breach of contract. Now, cause of action suddenly is under tort of negligence. Or, without prejudice, amendment to the statement of claim, if any, endorsed with the writ. All these things are not allowed. Meaning, if you wanted to do any of these things, regardless of close pleading or before close of pleading, you will need a leave. Now, I didn't say anything different. You don't even have to jot out any notes because whatever I say, it's all from the statute. Okay? Again, learn to read the statute. However, it says here, unless the amendment is made before service of the writ. So I think before you serve, you got the writ registered already. Before you serve, you want to do anything also you can. If after you serve already, you wanted to change, amend something, this one. You can do one time before the billing close. If you want to amend 2 times, you need leave. If you want to amend after close, you need leave. But can you do all these things after you serve the statement, after you serve a writ? Cannot. You will need leave. Okay, that's how you read it. What about rule 3? Same. This is pleading without leave. Pleading, just now is read, just now is pleading. Same. A party may, without the leave of the court, amend any pleading of his once at any time, before pleading close. Same thing. Order 18, Rule 20. Where an amended statement of claim is served on a defendant, the defendant, if he has already served a defense, may amend his defense. And the period for service of his defense or amended defense, as the case may be, shall be either the period fixed or under rules 14 days. Okay, very general, straightforward. Where amended defense is served on a plaintiff by a defendant, the plaintiff, if has already served a reply, may amend his reply. So that's why you need to know the pleadings before, or else you don't know what's a reply, all these things. The period for service, as the case may be, shall be 14 days. Okay? So you can read this on your own, nothing too difficult. Next one I want to read is 5. No, before I read 5, I want to read, okay, I read 5. I want to read 12 with you first. Okay, this one. Amendment of pleading by agreement. So you can amend the pleading, both parties agreed to amend. Okay, both parties agreed to amend. Notwithstanding the provisions of this order, any pleading in any cause or matter may by written agreement, this is pleading only, pleading, be amended before commencement of the trial. So now in pleading, if both parties before commencement of the trial, they agree to amend particular thing, they can have an agreement, can do it. The amendment under this one shall be filed at the registry and served on all parties within 14 days. This rule shall not have effect to a relation which amendment which consists of addition, omission, substitution. Still cannot. So if you want to do any of these, you will still need a leave. Okay? This one. All this one I highlight and read with you means it's important, it may come out in exam. Amendment of judgment or order. This is what we call slip rule. Clerical mistake in judgment or order or errors arising from any accidental slip may at any time be corrected by a notice of application without appeal. We will learn more about this in the judgment chapter. What is clerical mistake? RM 5,000, 50,000. Okay? Actually, you wanted to write RM 5,000. So you add one more zero there. The judge wrongly add one more zero in there. So the judge may use slip rule to amend the judgment. Or by right, it should be 8% interest. Okay, wait a minute. By right, it should be 8% interest, but the judge say write 6%. Not intended. Okay, not intended. Alright, not intended. But the judge rate 6%. So the judge may use slip rule to amend it. Clerical mistake judgment. So it cannot be like judge says Alex pay 10,000. Actually, judge want to say, then you say, oh, judge must be wrong. Ask judge to amend it. It should be Mr. Lee win. Cannot. Clerical mistake only this small minor mistake. Okay, I will explain like this first, because when we do judgment, we will come more to here, and there is a case there. Okay, there's a case there. Okay, so take it as it is first. Now let's come back to this one, Order 20 Rule 5. Order 20 Rule 5 here, it's regard whether writ or pleading with leave. Subject to Order 15, Rule 6, 6A, 7 and 8. What is Order 15? Order 15 is your join the parties, isn't it? Rule 6 is what? Means joinder, non-joinder, estates, okay, substitute a party if the person die, alright? The following provision of this rule, the court may at any stage allow plaintiff to amend his writ or any party to amend his pleading. Why plaintiff amend writ? Because writ is only by plaintiff. Why any party to amend pleading? Because pleading can be statement of claim, statement of defense, it can be defendant, it can be plaintiff. Okay? On such term of to cause or otherwise it may be just a matter. What does this mean? It means that when you amend, you're causing a lot of trouble, right? The court may say, Alex, so late only you amend. Okay, I will award Mr. Lee cost. Means, Alex, you have to pay Mr. Lee some ang pao money. Cost. Okay, sometimes you see this term. When an application to the court for leave to make an amendment mentioned in paragraph 345 is made after any relevant period of limitation current at the date of issue has expired, the court may nevertheless grant such leaves mentioned if it thinks it's just to do so. What does it mean? For example, 1st of January, okay, 2010, a breach of contract. Cause of action satisfied. So your limitation starts to run, isn't it? What case can you use? Nasri against Mensa. How many years? 6 years. Why? Section 6 Limitation Act. So Alex, okay, must sue Mr. Lee by when? The last date Alex can sue Mr. Lee is 31st of December 2015. Last date. Correct. Assuming Alex started suing around here. So no issue, no limitation issue. Okay? However, suddenly now, 2017, Alex wanted to amend what? He wanted to amend, okay? Let's see, this is your order 20. He wanted to amend. Now Alex sued Mr. Lee. He wanted to amend the writ or statement of claim to change from Mr. Lee to Mrs. Lee. Can or cannot? If we followed Order 20 Rule 5 sub 3, it says can. Why? An amendment to correct the name of a party may be allowed under, notwithstanding that it alleged that the effect of the amendment will be substitute a new party. Mr. Lee to Mrs. Lee, substitute. If the court is satisfied that the mistake sought to be corrected was a genuine mistake, okay? Genuine mistake, was not misleading, and such caused any reasonable doubt as to the identity pursuit. So, what is the requirement? You need a leave, isn't it? Here. And why is it allowed? Because we talk about limitation. Because you see, you start here. Okay? Due date here. Now, you come in after limitation, after 6 years already. Only then you wanted to change. And when you change here, it's as if it's treated as if the amendment is done on this particular date. When you, let's say, no, sorry. It's treated as if the amendment is done on this particular date when you start to sue. And let's say you start to sue is on 1st of January 2011. That is why we call this doctrines of relation back. Relate it back. When you do an amendment here in 2017, which is over the limitation period, the amendment will be treated as if it was done on the date when you file the writ and statement of claim. So that's why it's called doctrine of relation back. So you are allowed, if it comes under these three things, number 3, number 4, number 5. So what is this? Correct the name of the party. Allowed after limitation period. Second one, alter the capacity which a party sues, which be allowed if the capacity amendment made party sue in which a date of issued, okay? Allowed. Need leave also. Amendment may be allowed under paragraph 2, notwithstanding anything to add or substitute a new cause of action. If the new cause of action arise out the same facts or substantially the same fact as the cause of actions, distinct, then allowed. Anything not under this 3, 4, 5, not allowed to amend here. Because after limitation, anything outside 3, 4, 5, not allowed to amend here. And things under 3, 4, 5, even after limitation period, you still can allow to amend. Okay? Because doctrine of relation back. Now, I wanted to explain this number 5. What does this mean, number 5 means? 1st of January 2010. Let's say breach of contract. Cause of action completes. What is cause of action? What case? Lim Kian Chu Kun. That 3 factors. Now, let's say due date is when? 31st of December 2015. Due date. And assumes Alex sue on here. Okay? 1st of January 2011. Suddenly now, 1st of January 2017, Alex wanted to add a new cause of action, which is tort of negligence. Can or cannot? Can if what? If the new cause of actions arises out of the same fact, substantially the same fact as the cause of action in respect of which the relief has been claimed. So he can add here if the cause of action for tort of negligence was also completed here on the 1st of January. Then he can add on. If on the 1st of January, the cause of action for breach of contract completes, the tort of negligence only completes, let's say, around here. On 1st of September 2010. Okay? Okay, I'll give you an example. No, this example is not good. I'll give you another example. Okay, ignore this one. Okay, wait a minute before you get confused. Let's say this one like this is better. Let's say, okay, 1st of January 2010, breach of contract, cause of action complete. This is also the dates Alex filed claim. Okay, the due date limitation is this one. So no issue, right? Alex filed within 6 years. The date, the cause of action complete, he filed it straight. On these dates, here, 1st of January 2017, he wanted to add a tort of negligence. So, outside limitation period. So now we are looking at Order 20, Rule 5 sub 5. It says can, if the new cause of action arise out of the same fact or substantially the same fact as a cause of action in respect of which the relief has been claimed. So if he wanted to add here, he can do so if on these particular dates, the cause of actions for tort of negligence is also complete. Then only can allow. If now he wanted to add tort of negligence here, but the cause of action for tort of negligence, it's only completed here, the three factors, Lim Kian and Chu Kun, on 1st of January 2011. Is he allowed to do so? Is he allowed to amend the writ or statement of claim to add the new cause of action? Cannot, because at this particular date, when he filed the claim, only breach of contract, cause of action complete, tort of negligence hasn't happened yet. So you cannot. Tort of negligence only happened here. So you cannot file it. You cannot amend it. Okay? Take note. It says that new cause of action, you see, arises out of the same fact. Here, this fact also give rise to tort of negligence. Then can, on that date. But your tort of negligence only come out here. Cannot, because you file here. Means you file on this date, it happened later on, you go and add on something which didn't happen on the date when you file it. Cannot. Okay? Take note of this one. Right, so this is the one. So anything outside these three things, if you wanted to amend outside limitation periods, so again, example, 1st of January 2010, cause of action completes, let's say lah, okay? Due dates 31st of December 2015, due date limitations, all right? So you filed here, no issue. So now, 1st of January 2017, you want amend names. Can't, because we go Order 20, Rule 5 sub 3. You wanted to amend capacity. Can't. Order 20, Rule 5 sub 4. You wanted to amend cause of action. Can't. Order 20, Rule 5 sub 5, if you satisfy the cause of action happen on the same day. So even all these three things, you also need leave. Because here, leave. What if you now here, you wanted to amend something else? That is not name, not capacity, not cause of action. Totally different thing. Let's say you want to amend at X, something else. Cannot. Because the only exceptions allow it's this 3, 4, 5. This thing, 3, 4, 5. That is why you have a case. Now, let's look at the notes. So, now, let's look at principal amendment. The principles of amendment says this. Clarapit and commercial union, it's always your starting point. Clarapit and commercial union says, however negligent or careless may have been, first omission, my typo there. And however late the proposed amendment should be allowed if it can be made without injustice. There is no injustice if the other side can be compensated by cost. Cost your order 59. Okay, this 4 case is your principles. Malayan Banking and Ting Yin Yang. In this Supreme Court, the general principle is stated to be court will allow such amendment as will cause no injustice to the other side. It is also said, quoting of this case, the court will ask, memorize this. Okay, first time I say it today, memorize it. Is the application for amendment made bona fide? Will the amendment ask for cause no prejudice to the other side which cannot be compensated by costs? Are the amendment asked for such as to turn the suit of one character into another one? Because you amend, you totally change it. Just now you see one of the case, the other party say, nuisance, negligence, change it. But the court say no because the same facts give rise to it. So you see, you have to analyze the fact. Yamaha basically reaffirmed this Malayan Banking and Ting Yin Yang. Yamaha said the same thing as in Malayan Banking and Ting Yin Yang. Okay, you can read this on your own. Malayan Banking and Ting Yin Yang, Yamaha. You see here, whether bona fide, cost, or this thing. I didn't give you any of these 3 cases here because I think I didn't. Yeah. Then comes the case of Hong Leong Finance. Hong Leong Finance go one step further. It says that when dealing with an application to amend a pleading which introduce a new case in the claim of defense on the eve of trial, means a day before the trial, principles of Yamaha are not the sole consideration. Yamaha Malayan Banking is whereby you amend early of the trial. So the general starting point is always Clarapit and Commercial Union. Malayan Banking Ting Yin Yang or Yamaha is to amend the pleading or writs at early of the trial. This Hong Leong Finance factor, memorize it. Memorize it. It's late eve of the trial. So that's why I say Yamaha are not the sole considerations. Principles in Yamaha only apply early stage. That there has to be a cogent and reasonable explanation as to why it was filed late. Application to amend is not a tactical maneuver. Okay? That the proposed amendments must disclose full particulars for the court to ascertain if there is a real prospect of success, that lateness in the application cannot be necessarily compensated by payment of costs. Alright? Hong Leong is late on. So I give you this case I want you to read. And I give you the I didn't give you the summary, but I want you to read. If you can't, I already summarized here. I said here, this is the one that you need to read. Para 14 to 35. Okay, please read it. This is the case I want you to read. Others I already summarized for you. Alright? Now, few more before we finish. There are certain things where amendment totally not allowed. Leave, no leave, limitation, no limitation, don't care. Not allowed. Number 1, amendment to withdraw an admission consciously made. Admission is under your order 27. You consciously means you honestly said it, I admit I do this. Later on you find that, hey, why I admit it? Oh my God, it's against me. Then you want to withdraw it. Cannot. Amendment to raise a cause of action which accrued to plaintiff only after the action commenced. So this is similar to your Order 20 Rule 5. Your cause of action, breach of contract, happened on 1st of January. You file on that day. Now, you amend later on to say add on thought of negligence. But the thought of negligence cause of action is not complete on that particular date. The thought of negligence cause of action may be complete a month later after you have filed the writ or statement of claim. So not allowed. Amendment to add a party or raise a cause of action. Sorry, my typo. What's wrong with me? After the expiry of the relevation period under Order 2020 Rule 5. Okay, add a party or raise a cause of actions. Okay, after the expiry of relevant period, unless 20 Rule 5 applies. Okay, this is you. I want you to memorize a bit. Memorize this one. Memorize this one. This one you understand. I don't need. Application is not bona fide. Straightforward. Okay, so I give you some example that plaintiff sued for specific performance and damages. The defendant sought to amend his defense, asserting plaintiff had entered the sale as partnership agent or trustee. Earlier in this suit, the High Court had already found the plaintiff was not an agent or trustee, but had purchased in his own personal capacity. Trial judge was entitled to refuse because it was not bona fide. Earlier judgment had disproved. Partnership agreement did not even assist. They later on want to come and amend it. Cannot. Do you need to know this particular case? Now, if they're going to ask you a question, you probably need to, probably 7-8 marks, you're going to explain some. So if you can know this case, then of course much better. But I can tell you which one is the one that you really need to know. It is this one. Kyon Maru. Kyon Maru, you must know. Okay? Amendment turned the suit of one character into another character. Okay, I give you an example. You can read this one. Again, if you can, then you know the case. If you cannot, then never mind. Amendment is made after inexcusable too long. Okay, again, I give you an example. Amendment will cause prejudice which cannot be compensated by cause. If there is one case in here, amendment which is not allowed, that you really want to know, need to know, is this old case of Kyon Maru. So let's go through this case. In 1972, plaintiff shipped all this thing from here. So the vessel, the ship is called Kyon Maru, owned by a third defendant. The cargo never arrived. Plaintiff sued the third defendant as carrier and relied on bills of lading. Okay, if you do shipping, you know bills of landing. Now we call bills of landing that issue. In their original defense, the third party defense, they third party admitted they are the carrier of this thing. So then, since they admitted they are being the carrier, the plaintiff will prepare their case based on whatever admitted by the defendant, isn't it? 5 years later, the defendant wanted to amend their defense to withdraw this admission. Almost same thing like this Hollis and Burton. Withdraw admission, okay, consciously made. They wanted to withdraw this admission and allege at the material time the vessel was a chartered one. So what they say here, at first 1972, in their defense they said, we are the carrier. Obviously, then the plaintiff will rely on this defense and prepare the case. 5 years later, they wanted to pull back their admission and say, sorry, no, this one I'm not the carrier. It's actually we chartered it. Chartered means you rent it from someone else. This vessel belongs to someone else. Doesn't belong to us. Okay? He said this one belonged to the first defendant under this one. Plaintiff objected, arguing they would suffer serious prejudice if they had known they would have arrested another vessel on the first defendant, thereby obtaining security. The first defendant were now in liquidation. Because 5 years has passed, if on this particular day here, you said that I am not the carrier, it is the first defendant, they will go and arrest this Gulf King owned by this first defendant to use it as a security for their claim. In case they win against this first defendant, first defendant lost, they have some money to recover. But now 5 years has passed. The first defendant already bankrupt. And now you wanted to change here, now defendant, you wanted to change it to say this Kyon Maru belongs to the first defendant. If allow you to change it, then meaning you are saying I'm not responsible for this thing or whatever, this late delivery. Then meaning you want me, the plaintiff, to go after the first defendant. But the first defendant now after 5 years already go bankrupt. Even if I go after the first defendant, what money can I claim? I can't claim anything. So that you cannot amend. Because if you amend defendant, I will leave me with nothing to take back. Because of your own fault, defendant. So, although the plaintiff could not, strictly speaking, have arrested, solicitor have dodgedly pursued every opportunity. Allowing the amendment would therefore cause the plaintiff prejudice. Because if you allow the defendant to change this admission now, to say that, oh no, it's not mine, it's actually this first defendant. Even I go after the first defendant, I cannot get anything already. The first defendant already go bankrupt. It's not even possible to compensate me by costs. So they don't allow it. So Kyon Maru, you must know. Okay? Doctrine of relation back, I give you some example. So we talk about it already. There is one case I want you to know, which is a very important case of Instant Color and Inkmaker Asia Pacific. Instant Color is whereby plaintiff sue defendant. After limitation periods, plaintiff wanted to add a new defendant. After limitation period, plaintiff wanted to add a new defendant. First thing, the court say cannot because it doesn't come under any of those exceptions under Order 20, Rule 5, Sub 3, Sub 4, Sub 5. Second thing, why cannot? Why? It's not about can or cannot. Why cannot? Because if you add someone in now, after the limitation periods, okay, you cannot because you have violated the limitation rule. Here, the power amendment does not extend. So you know this because it's not under those exceptions. Relation back. This rule applies only to amendment under this one. Okay, you understand that. Authorities, general rule reaffirmed. Where a new defendant is added, the action commences on the date of joinder. Date of joinder, not retrospectively. So what it means is this. I'm sorry, why is there so many typo mistake this one? I'll amend it a little bit, okay, if I can tonight. So far, just now, we see all these things. Okay, it's all like this. You amend here. Let's say you amend name, capacity, or course of action. Let's say it's satisfied. It's what we call a doctrine of relation back. It goes back as if this amendment was done on the date where you filed for the writ or statement of claim. So for this defendant thingy, now it's like this. Now you wanted to add a new defendant. Add a co-defendant, or should I say. Okay? Obviously, it's over the limitation periods, isn't it? And they will not allow you because when this thing is added here, it's treated here. It's treated on these particular dates. When you add a defendant, it's treated no relation back, no this one. For this one, there is no relation back because it doesn't come under any of the exceptions. So the adding defendant would treat as if the defendant was added here. But how can you add here? Because limitation is 6 years. Due date is here. So if you look at the reasoning, plaintiff had added 8 years. Limitation had kicked in. Amendment can benefit relation back. Adding an outside is not the exception. Following, action against added begins at the date. So the defendant will rely on limitation. Allowing such amendment would unfairly deprive the new defendant of a vested limitation defense. Okay? Because it's outside the limitation defense. Outside the limitation on the particular date of 2017. The doctrine of relation back inapplicable and the joinder took effect on this and not from the original writ. Consequently, the plaintiff claim was time barred and the defendant was entitled to plead limitation. Okay? What he says here is, it doesn't come under this. Following Leaf Peasley, action against the added begins at the date 2017. So the defendant rely. If we allow such amendments, okay, would unfairly deprive the new defendant of a limited defense. Therefore, doctrine applicable, joinder took effect on this date, which is the one I give you example 2017, not from the original date. So doctrine of relation back doesn't apply here. So I want you to look at the reason because this king often came out in exam. Right, good then. Then we shall stop here. So we done pleading, amendments, and we still have one more, which is third party. We'll do it together with the third block next week. Okay? Alright, I'll see you in the next class. Okay? Bye-bye everyone. Bye.